Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Good morning or afternoon or evening. I have in front of me a ALJ decision. It is a fully favorable. And the reason why I wanted to bring part of it to your attention was because it involved essentially a pure mental health case for a young person in their 30s. So it was the kind of case where the person had filed and lost multiple times before. And then we got on board a couple years ago, started fresh, still knew it was an uphill battle and the chances were but we were able to persuasively show that the person would not be able to sustain work, at this point, any work, much less full-time work, of the simplest kind. But I wanted just to pull out what the ALJ found important, and you can figure that out oftentimes from just looking at the decision and seeing what the ALJ used to substantiate the award. Okay, so when you go to the first, if you've had an ALJ decision, you'll see that they do findings of fact and conclusions of law. That's a whole section, and within that is numbered, bolded paragraph headings, and sometimes there is unbolded narrative underneath each bolded paragraph heading that gives more details. So the first number, it's almost like the sequential evaluation process, is the finding that the claimant has not engaged in substantial gainful activity. That's the SGA, of which we have a playlist should you need to learn more about it, since January of 2023, which was the date the application for SSI was submitted. Now, SSI, this is only an SSI case, no SSD. This person had not been able to work in a really long time. So that was all that's available. Number two, and again, sequential evaluation, the judge reiterates the severe impairments he or she found. In this case, while there is a physical problem, which was the result of, a physical issue that had arisen, leaving the person with peripheral neuropathy. That's not going to render a younger person disabled from all jobs. It just, I would never expect to see it. So that was pretty much a nothing burger. It prevents probably medium and above jobs, maybe light jobs, but probably not in the eyes of the SSA as we typically see. But here are the important ones that were noted, which was schizophrenia, ADHD, and a in recovery substance use disorder. And when I say in recovery, like years worth. So I suppose they look at it as there's always the disorder if there ever was the addiction and the abuse. Perhaps that's the way they look at it. But anyway, that too was a nothing burger. So the severe impairments were schizophrenia and ADHD. And you'll see in a minute how that occurred. They do go on to point out where they get the information to find that they were severe impairments. And that's in the non-bolded narrative underneath the bolded heading. The third section, noting this is a listing. Remember, step 3, does it meet a listing, those severe impairments, any one of them? All you need is one. And here, and again, this is not typically common. However, it's almost the way you feel it must happen to win, to prevail with a younger individual on mental health. And I say almost always because there's, of course, exceptions. But anyway, and I will quote, the severity of the claimant's impairments meet the criteria of sections 12.03 and 12.11 of the particular CFR section that contains the listings. So some of the narrative that was used to support that it meets a listing. And remember, if we meet a listing at step 3, we don't generally have to go on to evaluate an RFC because a listing has been met. So it somewhat prevents that whole rest of that analysis from going forward. So the claimant alleged an inability to work, the ALJ says, in part to schizoaffective and attention deficit hyperactivity disorders. And then the ALJ cites to which exhibits those were in. And in this particular section, it was the E section, and which presumably, I'm thinking, contained the application, maybe the 3368, and the hearing testimony. That's who he cites to. And he pulls out things that the claimant testified to. Lives with the parents, never obtained a driver's license due to extreme anxiety, is able to do simple addition and subtraction, but anything like multiplication and division takes him long, tends to make decisions impulsively, and does not always think out his decisions, gets very anxious around others. When he is anxious, he may lock up, does not know what to say, or his thoughts start going too fast. Also has racing thoughts constantly, hears voices sometimes, and has difficulties with understanding and paying attention. For example, has to watch a movie multiple times before understanding it. Is currently attending a partial hospitalization program 3 days a week. And he referred to hearing testimony, but there's actually references in the medical file to that partial hospitalization, which I pointed out in my brief, but they didn't cite any further than hearing testimony. So I guess the hearing testimony was, enough. Now, this part is critical too. And this isn't often going to happen, guys. The case manager testified. And because this person has a case manager that helps them keep their appointments and keep everything on track, because they're obviously getting a lot of assistance if they're in the partial hospitalization. They have no job, they're poor. So there's, state assistance going on. So this case manager, very, very helpful, very, very dedicated, and had been working with the claimant for almost 10 years. Ironically, when the hearing was done and we felt it went very well, and I was speaking with her, she was shocked. She said that was the most pleasant. I guess she's testified before. I didn't know her before this. And it's usually a chit show. And she says it's a disaster, like not happy with maybe the ALJ's absorbing of what, she may be testifying about. Don't know. But also remember, every case is different. So it's really different. But anyway, the case manager was testifying only to her observations, not to the law or whether he can work or not, because that's really not her purview. But she could talk to specifics. And this is where it gets really important. This can also be done by sometimes a therapist, if they are willing. Sometimes they're not really willing to put much into their records. But she testified, and she was happy to do it, that the claimant requires direct assistance with breaking down simple tasks, that she sees his anxiety interfere with his ability to complete tasks at all, that he needs her assistance with 1 to 2 step tasks. And that specific description right there happens to be how it is described in some of the rules about if you can't even do a 1-2 step task, you could be disabled from all jobs. All jobs. Simple and obviously complex. So that was her testimony really tied in to something that's actually in the law. I have no idea if she knew that was in the law. Maybe she did, but nonetheless, she testified and the ALJ is telling us what she testified to. It's not me, even though I recall. She testified that the claimant has difficulty managing his medications. And I think there was rhetoric in the medical records where he had discussed with somebody that the parent actually sets out the medications for him. Changes in his current routine and structure increase his anxiety and result in him spiraling. So he needs a very set schedule. Um, it was also true that he's been in the same partial hospitalization for years and years. So it keeps him as good as he is. But what would it be like without that? And of course, that partial hospitalization, which is like 3 full days a week by and large, would interfere potentially with most jobs, if not all, that exist in substantial numbers. Um, Close it off with regard to the case manager's testimony by saying that the case manager testified that the claimant has an excessive need for assistance with a failed independent living attempt in 2020. And I do recall that failed living attempted. Just really needs to have ultra guidance on a near daily basis. That is what I wanted to point out. And remember, uh, he met the mental health listings that I noted. And the things that the judge pulled out were, some would say anecdotal. The case manager was anecdotal. Um, Anecdotal is still evidence if someone's testifying to it. Now, again, it's not going to pull the day if it's not really evident also from the medical records. But when the medical records suggest it could be so, and then you have a somewhat objective third party. I mean, a case manager, is it objective? They say doctors often aren't objective. They sometimes slap down the opinion of a medical treating doctor saying he's just parroting the patient. So I suppose they could say the same thing about a case manager. But is everybody really doing that? I mean, it doesn't it doesn't stand to reason. Um, but again, because the client's testimony, the claimant, and the case manager, and that was the only witness, corroborates and provide meat and details to what's alluded to in the records overall, uh, was really, really absorbed by the judge. Now, it's funny because I did have a RFC from the treating, it's like a psychiatric nurse practitioner who prescribes, and she was she gave a very, very good opinion, but the judge didn't really seem to take it to heart. I didn't know why. I always, if you've heard my other takes on it, getting a treating provider's, when I say RFC, I don't mean that big 9-page thing you're going to pull off the internet, but more like a tailored, you know, questions exacting type of thing, that relate to the actual claimant and their situation specifically. So it's got to be kind of drafted in a tailored way, cherry picking questions that will be, you can, that are corroborated in the medical record. And this case was an example where the judge just decided not to really go with that, but nonetheless provided a fully favorable award with a listing level. So I found that I was disappointed that the treating provider, the psychiatric, I guess, nurse practitioner who prescribes as well, and really knew this person very well. It's been a long time, that documented testimony of sorts was kind of kicked to the curb. End result ended up being just fine. But I do wonder why that is. And I wonder, is there this is back in 2024, so, it takes a couple months to get the decision. Is there a leaning or a push, an unofficial push to not to rely on treating providers' opinions on limitations? I mean, they did get rid of the treating provider rule, um, after a big push for that in 2015, 2016, and it became effective in the very beginning of 17. But, and maybe that's something to do with it. Don't rely on that. If you're going to win them on something else. Don't know. But the drive home point is those little details that you find in a function report in the claimant's testimony, that give particularly good examples, like actual examples that have happened that can illustrate. Like I remember the case manager did give specifics, like examples of, uh, and I can't remember off the top of my head, but it might have been like a, what kind of one, two-step task was not working. Maybe the shutting down business when anxiety is getting a little hyped up and the claimant, um, has difficulty expressing at those moments and kind of closes down. Something like that. There was a few of them. She did it. She did such a phenomenal job. Um, I want her to come work with me every day, but that's not happening. But it was really good. Um, Very dedicated professional, I will say. I was very pleased. Anyway, that's the only section I wanted to draw out today. Um, because it is difficult to prevail for a younger person when you have to prevail on a fully unable to do any job due to mental health. Really high burden, guys, really high burden. But medical records really need to be intricately looked at. And even though the judge kicked to the curb the treating provider's opinion as to limitations, that does not mean it did not make an effect on the judge's internal workings as to why he believes the person is disabled. He just didn't use it as part of his support officially. Part of the job, I think, is to show an ALJ why he should think the person is disabled. Show him everything that would point to that, everything pertinent, not like minutia. Because you want him, he's going to want to do the right decision. So you want to give him a reason to know that what you're proposing is the right decision. So you want to make the ALJ want to award. And so you have to pull out all that stuff that would make him convinced it's true, of course. And then the judges have a very skilled way of pulling out the evidence they think will probably best support it so that it doesn't get overturned on an audit afterwards or by the AC sua sponte or something like that. But anywho, just wanted to share that to you. I know there's so many people with angst that are under 50, severe mental health limitations, and they have such problems prevailing on these cases. And we do too. I mean, we take them to the extent we can. We always have that, it seems like full hilt going on, but it does successfully happen a lot more than you think if you get into the nitty-gritty and you take the time to pull out those details and point them out and get more and better treatment records, which can be a huge struggle in the mental health world. You know, like we couldn't get, I mean, those 3 full days a week of partial hospitalization, meh, couldn't even get details about that because it's more of a group thing, I suppose. Um, but perhaps the judge is well aware of how structured that is. And that was part of the whole argument. Without this very major structure, day to day, no, just always a structure, always a routine for this person. Not going out and making decisions. There was that 2020 attempt to live independently. It was a disaster, and partially because sometimes people have difficulty not being overly impressionable by people around them that are not looking out for their best interests. People that are probably as equally injured as they might be, but not necessarily on the same straight and narrow desire to improve one's lot or, take better care of themselves. So it's very easy to get pulled down the wrong path. And so that kind of helped establish that person really does need this superfine structure. And a superfine structure, by the way, is not something that's going to be within the customary tolerances of employment. And that's another reason why it can be a very strong factor in getting a prevail on a mental health, because there's a substantial loss in being able to self-adapt and handle oneself and go to work. It's like having to have a babysitter almost, or a companion aide to make sure the person gets there and gets there on time and sticks with it and doesn't, get upset about something and then go off the skids. Because that would be an accommodation, and that would not be what we consider within the customary tolerances or without an accommodation or Yeah, the jobs don't exist in a competitive work environment. It would not be considered competitive if that were a requirement that the person has that's such an aid, keeping them on the straight and narrow so they can show up at work 8 hours a day, 5 days a week. All right. Okay. So that was a good one. And I hope it helped for anyone who is pursuing a strong mental health case, particularly if you're not necessarily if you're under 50, but certainly if you are under 50. There's still burdens over 50, but under 50, I know you guys have it the worst. It is so, so difficult. And we all struggle with that, trying to find ways to um, get the true picture across. All right. It takes both. It takes the legal team and it takes certainly the claimant pursuing certain avenues of treatment that they might not have had the energy or the thought to pursue. All right. Have a great one, guys. I'll talk to you later. Bye.